January 14th, 2026, 9:47 a.m. Washington time. The Department of Justice unseals a 98-page federal indictment in U.S. District Court naming Donald J. Trump as defendant and what prosecutors describe as a coordinated criminal enterprise operating from the White House. The charges carry combined maximum penalties totaling 90 years in federal prison. Within 3 hours, Elon Musk posts a series of statements on X claiming political persecution and calling the indictment an attack on democracy itself. Those posts generate over 200 million views before sunset. I've analysed federal prosecutions for 4 decades. I briefed congressional committees on RICO cases when prosecutors reserve that statute for mafia organisations and drug cartels. And what's documented in this indictment isn't routine political misconduct or administrative violations. It's systematic application of organised crime statutes to presidential conduct, representing the most aggressive federal prosecution of any former chief executive in American history. Let me show you what the indictment actually alleges and why this prosecution changes everything about presidential accountability. The Racketeer Influenced and Corrupt Organizations Act was enacted in 1970 as a weapon against organized crime. Congress designed RICO to dismantle criminal enterprises by prosecuting patterns of illegal activity rather than isolated offences. The statute allows prosecutors to charge individuals who operate continuing criminal operations even when they don't personally commit every underlying crime. RICO requires proof of an enterprise, an organisation or association conducting affairs through a pattern of racketeering activity. That pattern must involve at least 2 predicate acts within 10 years from a list of specific federal and state crimes including fraud, obstruction of justice, witness tampering, and money laundering. The genius of RICO from a prosecutorial perspective is that it transforms multiple separate crimes into evidence of a larger conspiracy. A defendant might beat individual fraud charges by arguing each was a mistake or misunderstanding. But when prosecutors demonstrate 10 instances of fraud following the same pattern, involving the same participants, serving the same goals, that becomes evidence of an enterprise operating systematically to achieve criminal objectives. Federal prosecutors historically reserved RICO for cases involving traditional organised crime, mob families, drug cartels, and criminal gangs. Using RICO against corporate executives became more common in the 1980s following high-profile prosecutions of Wall Street figures. But applying RICO to a president represented a threshold no prosecutor had previously crossed, even during Watergate, when Richard Nixon faced impeachment for obstruction and abuse of power. The DOJ indictment alleges that Donald Trump led a criminal enterprise consisting of campaign officials, White House staff, attorneys, and business associates who executed coordinated schemes to defraud donors, obstruct official proceedings, and interfere with witnesses. According to the charging document, this enterprise operated continuously from 2019 through 2025, conducting affairs through patterns of wire fraud, mail fraud, obstruction, and witness tampering. The specific predicates listed in the indictment include conspiracy to defraud the United States through false representations about election integrity, obstruction of the January 6th congressional proceeding, wire fraud related to political fundraising campaigns that misrepresented how donations would be used, and witness interference involving communications pressuring individuals not to cooperate with federal investigations. Each count carries its own maximum sentence. Conspiracy to defraud, 5 years. Obstruction of official proceedings, 20 years. Wire fraud, 20 years per count, with the indictment listing multiple instances. Witness tampering, 20 years per count. When prosecutors stack these charges and apply RICO enhancements, the theoretical maximum reaches 90 years. The DOJ knew this indictment would trigger immediate accusations of political persecution. Attorney General officials briefed extensively on that expectation before authorizing charges. The decision to proceed, despite predictable backlash, reveals prosecutorial confidence in the evidence compiled through grand jury proceedings that remained sealed until the indictment's release. Federal prosecutors operate under internal guidelines requiring evidence sufficient to obtain conviction beyond reasonable doubt before bringing charges. RICO cases demand even higher evidentiary standards because they are complex, lengthy, and invite aggressive defense tactics. No prosecutor brings RICO charges against a former president without believing the evidence is overwhelming. The indictment's 98 pages contain detailed, factual allegations sourced from testimony, documents, and electronic communications obtained through subpoenas and search warrants. Former White House officials provided sworn testimony before the grand jury. Documents seized from Trump properties and business offices establish patterns of conduct. Emails and text messages demonstrate coordination among enterprise participants. The timing matters critically. The 2024 presidential election occurs in November. If Trump wins, he potentially controls the Department of Justice that's currently prosecuting him. A president cannot pardon himself from state charges, but federal charges become complicated when the defendant controls executive branch enforcement. This creates urgent pressure for prosecutors to advance the case toward trial before the election. Trump's legal team filed emergency motions within hours of the indictment's unsealing. These motions don't challenge the underlying facts, but instead raise constitutional questions. Can a president be criminally prosecuted for actions taken while in office? Does presidential immunity extend beyond civil liability to include criminal conduct? Do separation of powers concerns prohibit subjecting a former president to prosecution by his political opponents? These questions lack definitive Supreme Court precedent. The Nixon era established that presidents aren't immune from civil subpoenas. The Clinton era confirmed presidents can face civil lawsuits. But criminal prosecution of a former president for conduct during his term remains constitutionally unexplored territory. Trump's attorneys argue these unresolved questions require dismissing the indictment pending Supreme Court resolution. The DOJ counters that no one is above the law, including presidents. Prosecutors note that Trump is a private citizen, facing charges for conduct that would be criminal regardless of his former position. They argue that accepting presidential immunity from criminal prosecution would establish a dangerous precedent where chief executives could commit crimes with impunity. Trump's reaction followed patterns established during previous legal challenges. Immediate public messaging framing prosecution as political persecution, combined with aggressive fundraising appeals to supporters. Within hours of the indictment's release, Trump posted a video statement directly to social media platforms. The video portrayed the charges as an attempt to steal the 2024 election by criminalizing political opposition. Trump claimed the indictment proved the justice system had been weaponized against him. He warned supporters that prosecuting a former president established precedent that could be used against anyone who challenges the political establishment. The message was clear: this prosecution targeted Trump but threatened every American who questions government authority. The fundraising response exceeded expectations. According to campaign sources reported by multiple news organizations, Trump's political action committees generated over $20 million within 8 hours of the indictment's release. Small dollar donations dominated, suggesting grassroots enthusiasm rather than major donor support. The average contribution was $47, indicating broad-based engagement from Trump's core constituency. Early polling showed Trump's support within the Republican base remained remarkably stable despite the charges. Approximately 72% of Republicans surveyed expressed belief that the prosecution was politically motivated rather than based on legitimate evidence. This created a paradox where serious criminal charges actually strengthened Trump's political position among supporters who viewed the prosecution as confirmation that establishment forces were conspiring against him. This dynamic complicates DOJ strategy significantly. In typical federal prosecutions, indictment signals the beginning of a defendant's isolation. Co-defendants cooperate. Financial resources dry up. Public opinion turns against the accused. But Trump transformed indictment into political fuel, using charges to mobilize supporters and reinforce narratives of victimization that resonated with his base. Elon Musk's response elevated the story from legal proceeding to global spectacle. Musk didn't issue a single statement. He launched what analysts described as a coordinated information campaign, using X as the primary platform. Within 3 hours of the indictment's release, Musk posted over 20 separate messages questioning the prosecution's legitimacy. Musk's posts claimed the DOJ was engaging in political persecution designed to prevent Trump from running in 2024. He accused unnamed officials of coordinating the indictment's timing to maximize political damage. He suggested the charges were fabricated or exaggerated to criminalize behavior that previous administrations engaged in without consequence. Most significantly, Musk shared alleged internal communications that he claimed showed evidence of political motivation behind the prosecution. The impact was immediate and measurable. Hashtags defending Trump dominated global trending topics within hours. User engagement on X surged past 50 million interactions in a single day. Conservative media outlets amplified Musk's messaging, creating a feedback loop where his posts became news stories that generated additional social media discussion. Musk's influence stems from multiple sources. As the world's wealthiest individual, with a net worth exceeding $200 billion, he commands attention that few private citizens can match. As owner and CEO of X, he controls one of the world's most influential communication platforms with approximately 500 million active users. As a polarizing figure who generates intense loyalty and opposition, his statements create engagement regardless of their accuracy or fairness. The scale of Musk's intervention represents something unprecedented in American legal history. Previous high-profile cases attracted media attention and public commentary, but no previous federal prosecution faced real-time opposition from someone with Musk's resources, platform access, and willingness to directly challenge DOJ credibility before any evidence was presented in court. This creates complications for prosecutors who typically rely on courtroom procedures to establish facts and counter defense narratives. When defense messaging reaches hundreds of millions of people before trial begins, public opinion may crystallize around narratives that evidence later contradicts. Jurors theoretically remain impartial, but jury pools draw from populations exposed to months of partisan messaging before trials commence. The indictment places extraordinary pressure on multiple institutions simultaneously. Federal courts must manage a case that will generate unprecedented public scrutiny and political interference. The judiciary faces questions about whether fair trials can occur when defendants mobilize massive political movements and when billionaires use global platforms to influence public perception. The DOJ confronts challenges that go beyond legal complexity. Prosecutors must prove their case while defending against claims of political motivation. They must navigate procedural challenges designed to delay trial past the 2024 election. They must manage witness protection for cooperators facing harassment from Trump supporters. They must coordinate with a judiciary that may include Trump-appointed judges. Congress faces pressure from constituents demanding either aggressive oversight of what they view as DOJ overreach or accountability for Trump's alleged crimes. Republican members largely rallied to Trump's defense, characterizing the prosecution as weaponized justice. Democratic members urged respect for judicial processes, while emphasizing that no one is above the law. The partisan divide made legislative oversight more complicated, with each party's position predetermined by political loyalty rather than evidence evaluation. Media institutions struggled with how to cover charges that many Americans viewed through partisan lenses. Reporters attempted to explain complex legal concepts to audiences with a limited understanding of RICO statutes and criminal procedure. Commentary divided between analysts emphasizing the charge's seriousness and those highlighting potential overreach. The resulting coverage often reinforced existing beliefs rather than providing neutral information that might shift opinions. Most significantly, the prosecution tests American democratic institutions in ways they weren't designed to handle. The founders established checks and balances, assuming actors would prioritize national interests over personal or factional goals. They anticipated corruption but didn't envision scenarios where a former president facing criminal charges could maintain sufficient political support to win election while under indictment. The critical question is whether this prosecution represents aberration that disappears after Trump or precedent that fundamentally changes presidential accountability. Multiple factors suggest the shift is permanent regardless of immediate outcomes. First, the legal infrastructure developed for this prosecution establishes templates for future cases. Prosecutors demonstrated that RICO statutes can apply to presidential conduct. Courts will evaluate constitutional questions about presidential immunity from criminal prosecution. Whatever precedents emerge will shape how future presidents understand the legal boundaries of executive power. Second, the political dynamics created by prosecuting a former president cannot be easily reversed. If Trump is convicted, his supporters will view the verdict as political persecution regardless of evidence. If Trump is acquitted, his opponents will claim the justice system failed. Either outcome reinforces partisan divisions and reduces faith in judicial neutrality. Future presidents will operate in environments where legal accountability threats are continuous regardless of actual conduct. Third, the information warfare surrounding the prosecution changes how legal cases function in highly polarized societies. Musk's intervention demonstrated that defendants with sufficient resources and platform access can shape public narratives more effectively than prosecutors relying on courtroom procedures. This asymmetry advantages wealthy, politically connected defendants in ways that undermine equal justice principles. Fourth, the electoral implications create perverse incentives. If prosecution strengthens Trump politically by allowing him to claim victimhood, other politicians may welcome indictment as campaign strategy. If prosecution successfully eliminates Trump from political competition, opposing parties may view criminal charges as effective tools for removing political threats. Neither dynamic serves justice or democratic stability. Most fundamentally, the prosecution reveals tensions between formal legal equality and practical political reality. In theory, former presidents face the same legal accountability as ordinary citizens. In practice, former presidents possess resources, loyalists, and platforms that allow them to resist prosecution in ways unavailable to typical defendants. The gap between theory and practice creates legitimacy problems regardless of how individual cases resolve. January 18th, 2026. The federal judge assigned to Trump's RICO case schedules an initial status conference for February 15th, signaling that trial proceedings will begin moving forward despite defense motions to dismiss. Prosecutors file notice indicating they intend to call over 40 witnesses and introduce thousands of pages of documentary evidence. Trump's legal team requests additional time to review materials, arguing that the complexity and volume of evidence requires extended preparation periods. The 98-page indictment, unsealed 4 days earlier, wasn't just a charging document, it was a statement that the Department of Justice believes no position, not even the presidency, provides immunity from criminal prosecution for conduct that prosecutors characterize as leading a racketeering enterprise. The 90-year maximum sentence attached to combined charges eliminates any possibility that conviction would allow Trump to resume political life. This is an existential legal battle, not a procedural dispute over administrative violations. Elon Musk's intervention within hours of the indictment's release transformed a legal proceeding into a full-scale information campaign where public opinion became as critical as courtroom strategy. His posts, generating over 200 million views, demonstrated that modern prosecutions occur in dual forums, courtrooms bound by evidence rules and public arenas where engagement metrics matter more than factual accuracy. For Trump, the prosecution represents both grave personal threat and potent political opportunity. A conviction would almost certainly end his political career and potentially result in significant prison time given his age and the sentence lengths involved. But the prosecution also provides a platform to reinforce narratives that resonate with his base. That establishment forces are conspiring to silence authentic voices. That the justice system serves political rather than legal objectives. That resistance to these forces is patriotic rather than criminal. For the DOJ, the case represents a high-stakes test of institutional credibility. Prosecutors must demonstrate that their decision to bring charges rested on evidence rather than politics, that RICO statutes apply appropriately to the alleged conduct, and that presidential accountability isn't just rhetorical commitment, but enforceable reality. Failure to obtain conviction would vindicate claims that prosecution was politically motivated. Success creates precedents that reshape executive accountability for generations. For American institutions, the prosecution reveals fundamental tensions in democratic systems designed for an earlier era. The founders anticipated corruption but didn't envision mass media, social platforms, or billionaires with reach exceeding traditional institutions. They established judicial independence but didn't address scenarios where defendants mobilize political movements that threaten judges and witnesses. They created accountability mechanisms but didn't consider whether those mechanisms function when half the country views prosecution as persecution. The coming months will determine whether judicial processes can function fairly under unprecedented political pressure, whether evidence-based prosecution can succeed against defendants who excel at narrative warfare, and whether institutions designed to constrain power can adapt to challenges who understand modern communication better than institutional defenders. The 98-page indictment, the 90-year potential sentence, and the 200 million views on Musk's responses all signal the same reality. This isn't a conventional legal case. It's a test of whether formal legal equality can function in a system where some defendants possess resources and platforms that effectively place them beyond traditional accountability mechanisms. That test will shape American democracy long after this specific case concludes.